We provide bold,
legal insight and business leadership
to forward-thinking people and organizations.
We believe in better
and bold outcomes
and meticulous focus
in finding the solutions others might miss.
By building our practice around the best minds in the legal profession.
And outside of it, too. We believe the pursuit of better starts with people.
Our colleagues, our clients,
and the people who depend on them.
We are committed to truly understanding
the individual needs
of those who depend on us,
so we can help them go from where they are
to where they want to be.
We are.
Husch Blackwell.
Husch Blackwell.
Husch Blackwell.
We are Husch Blackwell.
Good morning, everyone. I'm Marcy Koski, a partner in and leader of Husch Blackwell's Consumer Financial Services practice. Thank you for joining us today. Before we begin, I'd like to go over a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer your questions during the webcast today, but if a fuller answer is needed or we run out of time, we will be in touch to answer it. A PDF of the presentation is also available in the resources folder. This program has been approved for continuing legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. That is all for the housekeeping items. Let's get started with our program. We are excited to be talking with you today about the U.S. Supreme Court's recent Telephone Consumer Protection Act, i.e. TCPA, decision in Facebook versus Duguid. Joining me today are two of my consumer financial services teammates, Lauren Capitini and Scott Helfand. Lauren is a consumer finance compliance and regulatory attorney, having practiced in this space for nearly her entire career. She advises financial services clients, including banks, credit unions, non-bank lenders, finance companies, and financial services vendors on challenging and complex state and federal compliance issues. One such issue, of course, is compliance with the TCPA. On the other side of the coin, we have Scott Helfand, a powerhouse consumer financial services litigator who has been practicing in this space for his entire career as well. Scott defends consumer financial services providers, insurers, and other businesses, drilling down for business-focused solutions in complex litigation. This includes defending companies in court against alleged TCPA violations, Scott having spent over a decade defending companies against such claims, including in nationwide class actions.
We provide bold,
legal insight and business leadership
to forward-thinking people and organizations.
We believe in better
and bold outcomes
and meticulous focus
in finding the solutions others might miss.
By building our practice around the best minds in the legal profession.
And outside of it, too. We believe the pursuit of better starts with people.
Our colleagues, our clients,
and the people who depend on them.
We are committed to truly understanding
the individual needs
of those who depend on us,
so we can help them go from where they are
to where they want to be.
We are.
Husch Blackwell.
Husch Blackwell.
Husch Blackwell.
We are Husch Blackwell.
All
All right, all. Sorry for the technical difficulties. I'm sure you all really wanted to see that video again. We know how fantastic it is. So today we have an exciting agenda for you. First, we're going to hand it over to Scott momentarily, who is going to talk a little bit about how we got to the decision in Facebook versus Duguid. So really giving some great background of the TCPA. And then he'll launch into really talking about what the decision said, what it means, and what's next for the TCPA. Thereafter, I'm going to come back and join you on the screen to really talk about the kind of practical, hard-hitting issues, boots on the ground knowledge as to what exactly you're going to do moving forward, what the import of this decision is, and the outstanding risks that you might have. So at this point with that, I am going to go ahead and turn it over to our powerhouse TCPA litigator, Scott. Take us away, Scott.
Thanks, Lauren. I'm sure with that great introduction by both you and Marcy, I can now only disappoint. Thanks for setting me up for failure. But in all seriousness, thanks everybody for attending today. When we talk about the TCPA, we need to think about sort of where we started with the TCPA and where we're going next after Duguid and how we got to Duguid. And so, like most things in the last 30 years, we can best understand this journey through the prism of The Simpsons. So, what do The Simpsons tell us about the TCPA's journey? Well, these are still shots of an episode in which Homer got a hold of an auto dialer. Marge, as usual, was a little concerned about his schemes and wanted to know if it was illegal. But Homer assured her that it would be fine, that they would make lots of money. And so he programmed the dialer to dial sequentially every phone number in town. Eventually, the town got in an uproar about this. And the police came in and raided the Simpsons house, destroyed the auto dialer. Homer wanted to know why they had destroyed, quote, Marge's auto dialer, that was that. So what does that tell us about the purpose of the TCPA? It tells us that the TCPA was designed to combat abusive telemarketing practices. And that's a theme that we're going to see again when we get to Duguid. But first, let's talk about, again, the origins of the TCPA. And it's not just The Simpsons that tell us the basis of the TCPA, though they're a great window into it. It is the statements on the floor during the debate of one of the sponsors of the TCPA. And that was Senator Hollings, who said, quote, computerized calls are the scourge of modern civilization. They wake us up in the morning. They interrupt our dinner at night. They force the sick and the elderly out of bed. They hound us until we want to rip the telephone right out of the wall. So again, we're talking about sort of calls not really connected to any specific person or someone with whom the caller has a relationship. So what does the TCPA say? Well, it generally prohibits the use of certain technology, whether an automatic telephone dialing system or an ATDS, as I'll call it today, and most people do for shorthand, or a pre-recorded voice or a fax to contact folks without their consent. And the level of consent depends on the type of call. For servicing or informational calls, you have prior express consent, which is just basically the person has voluntarily provided his or her number. And then for marketing calls, you have a requirement of prior express written consent, wherein they affirmatively state that they're interested in receiving marketing calls or what have you. And we'll get into that in more detail later on. But what you have to understand going into Duguid is that it focuses only on one aspect of the TCPA, and that is the ATDS aspect. The rest of the TCPA is left unchanged. So what does the TCPA prohibit when it comes to the ATDS? Well, the TCPA defines an ATDS as equipment which has the capacity to store or produce telephone numbers to be called using a random or sequential number generator and to dial such numbers. So that's what the statute says. Okay, so great. We passed the statute. We're getting rid of equipment using random or sequential number generation. We're smashing it, and everybody's going to be happy. Well, not exactly as these things turn out, because between 2003 and 2015, the FCC, the Federal Communications Commission, which is the federal agency charged with interpreting and implementing the TCPA, issued a number of rulings in which they expanded the definition of of an ATDS, or arguably expanded. That was the debate in Duguid, to include essentially any equipment that could store numbers and dial those numbers automatically. So, for example, equipment that calls from a customer list. That was the FCC's pronouncement in a number of rulings over the course of about a dozen years. And while the FCC might have had a laudable purpose, in basically ensuring that folks don't run around the TCPA's prohibition, and also ensuring that privacy concerns are appreciated and met, as these things go, the plaintiff's bar picked up the TCPA baton and used what the FCC had pronounced, and what some other courts have pronounced, particularly the Ninth Circuit, and essentially turned it into a cottage industry to file suits and recover billions and billions of dollars, not from rogue telemarketers, as were the target of the TCPA as initially enacted, but rather against legitimate businesses trying to efficiently and quickly communicate important information to consumers that consumers would want to get. For example, some unauthorized person is trying to access your bank account or what have you. So taking the expansive definition of a ATDS, the plaintiff's bar basically, as I said, turned into $1 billion cottage industry in which legitimate businesses were suffering greatly. That takes us from the original purpose to maligned poster child. Dissenting from one of the FCC's key rulings, expanding or arguably expanding the definition of an ATDS to cover any equipment that dials automatically from a list, then Chairman Pei of the FCC said the TCPA, quote, has strayed far from its original purpose and has, quote, become the poster child for lawsuit abuse. So that's where we were between 2003 and 2015. Now we come to 2018 and the ACA International decision from the DC Circuit. So what happens in ACA International? Well, in ACA International, the petitioners challenged the FCC's rulings on the meaning of a ATDS. And the DC Circuit struck down the FCC's rulings. And in so doing, the DC Circuit found particularly problematic two aspects of the FCC's rulings. The first was what functions constitute an ATDS. And the DC Circuit found that the FCC had failed to be consistent because while at times the FCC had said that there has to be random or sequential number generation, at other times, as noted, it had said simply dialing from a list. Any kind of automated dialing is sufficient. And the DC Circuit said when, you'll pardon the colloquialism, when the FCC is talking out of both sides of its mouth, that is not going to be considered reasoned decision making. And therefore, that is arbitrary and capricious. the DC Circuit also took issue with the FCC's understanding of capacity, as in equipment that has the capacity to store or produce numbers using a random or sequential number generator. The FCC had said essentially, the only thing we know doesn't have the capacity to store, produce, et cetera, to automatically dial is a rotary phone. Anything else might have the capacity. And the DC Circuit was concerned that this would compel the conclusion that smartphones have the capacity to function as auto dialers because apps carrying the requisite features can be downloaded. And the DC Circuit found that this was arbitrary and capricious. But, and this is the important but, is the DC Circuit did not actually provide a definition of either the functions that make up an ATDS or are required to be an ATDS or the requisite capacity. So the DC Circuit simply struck down FCC's interpretation and basically put us back in the drawing board before the FCC had started issuing its various rulings between 2003 and 2015. So what happened next? Well, what usually happens in these circumstances?
Hey, Scott.
Yes, Marcy.
Question for you. So as you mentioned, I mean, the FCC has literally issued hundreds of pages interpreting the TCPA and the ATDS. So, I mean, and really, if you're a company trying to comply with it, it really is quite mind-boggling. So what interpretation of the FCC did the ACA court strike down? After this decision, did the FCC have to start from scratch? Can you talk a little bit about that?
Sure. That's actually a really good question. And it was an issue that came up in the ACA decision. So the FCC took the position that, essentially the FCC had started in 2003 interpreting an ATDS to include equipment that dials stored numbers. That is, that doesn't require random or sequential number generation. And the FCC said, hey, you can't challenge in 2015. It's too late to challenge that decision. What the DC Circuit said is basically by reaffirming that decision over and over between 2003 and 2015 and those numerous rulings, the FCC essentially continued to open itself up to challenge, culminating in 2015 when the FCC basically issued its most clear statement that it intended that an ATDS include equipment that dials automatically from a stored list. And so, basically every ruling that came before that, was brought up in that. And so that's the FCC is now, was essentially told yes to start from scratch, but the FCC in the 3 years or going on 3 years since then has not done anything else with this, and we can get back to that a little later in terms of what might be next. But in any event, over 2018 to 2020, there develops a circuit split in the courts of appeals over the meaning of an ATDS. So in the 3rd, 7th, and 11th circuits, the courts go back to the original meaning of the statute and the original purpose of the statute, and they say, the equipment must involve random or sequential number generation. Dialing stored numbers automatically is not sufficient without random or sequential number generation. The 2nd, 6th, and 9th circuit take the opposite view, and they say, well, you can interpret it to not require random or sequential number generation in all instances. And that's the way we want to interpret it because we're concerned about, companies trying to get around the TCPA or, what have you. And, frankly, the grammar that these courts relied on was a bit of a stretch, and the reasoning sort of strayed from the TCPA's original purpose, and arguably took upon the courts the opportunity and the role of sort of rewriting the statute to modernize it, which, as we know, is not the court's role. That's Congress's role. And so we wind up in April of 2021 at the Supreme Court deciding Duguid and resolving the circuit split. And I want to read the opening line. This is the opening line from the court's decision, and I think it tells you exactly where the court is going and why it's going there. Quote, the Telephone Consumer Protection Act of 1991, TCPA, prescribes abusive telemarketing practices by, among other things, imposing restrictions on making calls with an automatic telephone dialing system. So right away, the court, and notably, this is a 9-0 decision, it's unanimous, the court is taking us back to the TCPA's original purpose with the opening line and just sort of telegraphing its decision. So Duguid, the factual background, I'm not going to read the slides, but just to, tee up the issue is Facebook has a system where Facebook users can opt in to receive notifications via text, which everybody at this point agrees that a text is a call for TCPA purposes, though that could change. The person then will receive a notification text from Facebook if an unauthorized, or let me step back, if someone is trying to access his or her account from an IP address that Facebook doesn't recognize. So Duguid received one of these texts and said, hey, Mr. Duguid, someone is trying to access your account from an unknown IP address. But Duguid never had a Facebook account. Now, there are a number of reasons why this might have happened. For example, the number of the previous user or the number of the Facebook user might have been reassigned to Duguid. Again, not really important why this happened for purpose of the decision. What is important is that it did happen, that Duguid didn't have consent, and so he brought a putative class action against Facebook for violating the Telephone Consumer Protection Act, and alleged that by dialing automatically from a list of stored numbers, Facebook had violated the Telephone Consumer Protection Act by using an ATDS, and Facebook moved to dismiss and said, hey, Mr. Duguid doesn't allege there's any random or sequential number generation involved, throw him out. And the district court agreed, and the district court said, I'm looking at the statute, it says random or sequential number generation, you don't allege random or sequential number generation, you're out. So Mr. Duguid appeals, it goes to the Ninth Circuit. The Ninth Circuit, consistent with a previous ruling of its own in a case called Marks v. Crunch Fitness, said no, random or sequential number generation is not required. You can be held liable simply for dialing numbers stored automatically from a list. And so, yes, Marcy.
Just a couple comments and a question for you. You mentioned in just a little bit ago that call is a text, and if I believe and remember correctly, I think that was brought up during oral argument. Why is a call a text? So I thought that was interesting. And then also, talking about the fact pattern here, it seems to me, is this the kind of fact pattern that's emblematic of the cases that you've litigated? It seems to me that, if you're getting these messages, just ignore them and move on. Why have these cases been worthwhile to litigate and fight about?
Sure, Marcia, those are great questions. So let me start with is it emblematic of the fact pattern that I've litigated? Yes and no. I have litigated, these are what are known as wrong number class actions, and I have litigated those, and I still firmly believe that those are not appropriate cases for class certification, in most cases, because how do you identify the individuals who you incorrectly called, right? Presumably you don't know that, although there could be circumstances where you would. So I guess I can see that. But in any event, that is one fact pattern. The other is, and the most common, frankly, in my experience, is either lack of consent or revocation of consent. So the plaintiff alleges either that he or she did not consent in the first place to receive the call, or more often these days, just because companies have gotten wise to needing to get consent to auto dial people. More often these days, it's a claim that the person revoked consent. And again, the good news from the company's perspective on a revocation of consent is those tend to create individual fact patterns, and so arguably counsel against class certification, though the plaintiff's bar tries to get around that by saying the defendant has a pattern or practice or doesn't have policies to effectively recognize revocation of consent. So those are sort of the two big issues. But to your other point, as far as why why someone doesn't delete the text and move on, well, I guess I would use the example of the infamous woman in Pennsylvania who bought, I think it was something like 66, I'm going to get the number wrong, but she had 60 cell phones in a picnic basket, or that's a picnic basket, I guess. And she had these cell phones, and she just waited until, after a number was reassigned, someone accidentally called one of the cell phones, and then she filed a TCPA claim against them, right? So, it's as a longtime colleague of mine used to say, it's an entrepreneurial system of justice, I guess. And so that's sort of the answer to the question why these people don't just ignore it and move on. And certainly the plaintiff's bar isn't going to ignore it and move on. So anyway, so getting back to Duguid, you have the holding, which I have on a slide here. Sort of skip that. And the holding is that, as defined by the TCPA, an ATDS is a piece of equipment with capacity to both store or produce telephone numbers to be called using a random or sequential number generator and to dial those numbers. The question before this court is whether that definition encompasses equipment that can, quote, store and dial telephone numbers, even if the device does not use a random or sequential number generator. It does not. To qualify as an automatic telephone dialing system, a device must have the capacity to either store a telephone number using a random sequential number generator or to produce a telephone number using a random or sequential number generator. And so that's the holding of Duguid. Storing and dialing automatically, not enough. It's got to involve random or sequential number generation. And just as a step back, because I know there's sometimes some confusion. The word number is really used in two senses in the TCPA and various decisions interpreted. On the one hand, you have random or sequential number generation, and that's really about digits. The person's like randomly sequentially generating phone numbers like 555-1212, 555-1213, 555-1214, et cetera, et cetera. And then the other is, phone number. They're using the string of digits to create a phone number to call. So anyway, the Supreme Court basically has two main aspects of its reasoning, right? The first is is grammatical. And while this is really exciting to me, I'm not going to subject you all to my grammatical nerdiness. I will just say that the Supreme Court said that the best way to interpret the language from a grammatical perspective was that the words to using a random or sequential number generator modified both the words store and produce. So storing and then skipping down to the next provision, dialing, not enough. Need to have a random or sequential number generator. The bigger and more important aspect of the court's decision for going forward is the statutory context discussion. And here, the court got back to the TCPA's original purpose. The TCPA was enacted to prevent abusive telemarketing practices, which Congress believed were particularly problematic for society. And the examples the court gave, this is from the TCPA text itself, is, one of the specific items listed that you can't do is dialing emergency room numbers, right? And the court noted that these prohibitions target a unique type of telemarketing equipment that risks dialing emergency lines randomly or tying up all or sequentially numbered lines in a single entity. And that was considered particularly problematic. And the court said, expanding the definition of an auto dialer to encompass any equipment that merely stores and dials telephone numbers would take a chainsaw to these nuanced problems when Congress meant to use a scalpel. And again, we get back to the original definition, the original meaning, the original purpose, and the court basically saying, Justice Kagan, you'll forgive the aside of Supreme Court nerdiness, but Justice Kagan said a few years back, we're all textualists now. We all look at, the meaning of the text and sort of what was going on at the time it was passed. And sure enough, 9-0, the court gets back to the original purpose of the TCPA. And, Duguid made a number of good arguments. He said, well, companies will use this to get around the TCPA prohibition, and this is not going to cover all of, potential problematic conduct. And the court, basically said, tell it to Congress. Not our job. This is the law. Congress can pass it. This is grammatically the law it passed. This is the concern it had. If you want to bring it up with Congress, go ahead. So now what? I apologize. I'm not doing a great job on my slides here, but I'm reading them, so that counts. Anyway, what's next for the TCPA? Well, there's a capacity battle. There's a battle over footnote 7, which is going to soon be known as the infamous footnote 7. And then there's discussion of other TCPA prohibitions, federal legislation, and what the FCC might do. So capacity. What's capacity all about? Well, the statute doesn't define an automatic telephone dialing system as equipment that simply does the prohibited actions, but has the capacity to do the prohibited actions. And Duguid, they kind of go back and forth. You can see on this slide. On the one hand, they say, well, it's got to have the capacity. On the other hand, they say use, right? And the statute clearly says capacity. So what does capacity mean? Well, the plaintiff's bar is going to argue that basically, anything has the capacity to randomly or sequentially generate numbers. Given the way technology works these days, I can just download an app or, add a piece of software or hardware, and all of a sudden, even if the equipment was just dialing from a list, it now randomly or sequentially generates numbers. And so I think that's problematic, but it's going to be expensive to litigate. I think it's problematic for two reasons. First is just commonsensically, you're going to swallow all the equipment the Supreme Court just threw out as within the ATDS definition. So that's clearly a problem. The second is that there are these Duguid decisions that recognize that, we have to sort of cabin the word capacity. Otherwise, everything has the capacity, getting back to our infamous smartphone. And they've taken different ways of saying this, but basically what it's going to come down to is a top to bottom reconfiguration of equipment, or having to, add features to the equipment is probably not going to constitute capacity. Unfortunately, while that makes sense to me and that's consistent with the Supreme Court's decision, it's going to be expensive to litigate that issue, and who knows what a court will do. So that's definitely going to be one of the next battlefronts. Yes, Marcy.
So as I understand it, Duguid didn't touch on capacity because the conclusion was there was no capacity, right? So there was no battle over what capacity meant. Is that right?
Yeah, I mean, I would say it this way. I think you put it well. I would say that in Duguid, there was no argument about capacity because the issue was simply random or sequential number generation or lack thereof. If the plaintiff in Duguid knew, how Duguid was going to eventually come out, he probably would have started off with a capacity argument, but he didn't know that. And so there was it basically was assumed for purposes of the decision that the equipment didn't have the capacity to store or produce using a random sequential number generator.
So in some ways, we're kind of back to post ACA here in arguing about capacity in some ways.
Yes, I think on the one hand, yes. On the other hand, I guess what I would say is I get back to several decisions. I note three of them here in the slide. Several decisions, including ACA, sort of talking about a commonsensical approach to capacity and what it means. But again, until this is conclusively resolved, it's going to get litigated. But I think there's some more low-hanging fruit that's going to get litigated first, which I'm going to get into in a minute, because capacity is expensive both from the company's perspective and from the plaintiffs, because it's going to come down to a battle of the experts, right? And the plaintiffs don't want to invest a lot of money. The plaintiffs who get paid, on contingency don't want to invest a lot of money just to lose, right? And so I think that while that is going to be a battle, I think it might be more of a game of chicken at like settlement discussions, that kind of thing, than so much of the actual litigation. But the next one I want to touch on is footnote 7, which I've had conversation with my friends in the plaintiffs bar about, and they say, well, this is going to be the next one. We're going to really hit it out of the park, this one. And, I hate to be overly optimistic, but I mean, this argument that I'm about to tell you is ridiculous. So what they're arguing is that in this footnote 7, the Supreme Court's basically saying that, well, if you have a equipment that dials only from a list, but then like randomly or sequentially picks the numbers to dial from the list, that's an ATDS. And as I said before, I think that is problematic for two reasons. One is that's just inconsistent with the entire reasoning of the Supreme Court's decision. Two, remember what I said earlier, there's really two ways to look at the word number in this context. One is a digit and the other is a phone number. If you're randomly or sequentially selecting phone numbers in a list, you're not randomly or sequentially generating digits, okay? The other thing is, of course, is put aside the random one. So what? If I call from a list, in order A, B, C, D, that's going to be a problem. But if I, call A, then C, it's not. And isn't that random? So again, I don't think this is going to get a lot of traction, but unfortunately in the TCPA, you really never know what courts are going to do. So we'll see. But I think that's a weak one. And then I want to sort of speed along here because I know Lauren's waiting to give a lot better insight than I am here, but let me just hit a couple more points. One is the other prohibitions on the TCPA. Here's a slide where it says, that was a telemarketer, not a robocall. It felt good to cuss out a real person. Basically, what I'm referring to here is the prohibition on the use of pre-recorded artificial voices. This is fairly common. It has not at all been affected by the TCPA. We're seeing a lot of litigation on this now, a lot of class actions about this. The other is the do not call prohibition. Again, this slide shows you sort of some of the limitations, but basically do not call prohibition. You don't need to be using an ATDS. You don't need to be using a pre-recorded voice. You just need to call someone who's on the do not call list without the requisite protection or the established business relationship or consent. There is a bona fide error defense. So there's that, at least with regard to the do not call list. And then finally, there is still the prohibition on faxing. That is, really, you think that not a lot of folks use faxes anymore, but just last year I defended a TCPA blast fax class action. So, I mean, they're still around, and it's still a prohibition. So that's it for what's next on the litigation front. On the federal legislation front, Senator Markey and Representative Husch were quick to criticize the court's decision and basically say now everybody's going to get called all the time. It's a bit of an overstatement, as Lauren's going to get into some of the other non-TCPA related restrictions on, just out and out blast calling. But obviously this is something that touches off a lot of political nerves. So certainly won't be surprised to see it introduced. Whether or not it gets through, different story. And the FCC may yet take up the opportunity, which it still has, to actually articulate a sensible definition of capacity. Hopefully, if it does that, it would be somewhere in line with the decisions I cited, and not, sort of anything has the capacity unless it's a rotary phone, which was the FCC's original approach to that idea. And with that, I appreciate everybody listening to me ramble on about the TCPA, one of my favorite things to talk about. And I'm going to turn it over to my colleague, Lauren Capitini, who is going to talk about practical next steps for companies.
All right. Thanks so much, Scott. I think the $1 million question is, right, can we stop worrying about TCPA? And if Scott's, component of the presentation was any evidence of this, the answer is no. I mean, I've stuck with our Simpson theme here, but, unfortunately, we can't stop worrying about the TCPA, and there's a number of reasons for that. So let's talk a little bit about what those practical implications of Duguid are. So the way I've been thinking about this in contemplating how best to describe the practical implications here is I'm thinking about pizza. I'm not hungry right now, but let's think about pizza. If you think about all the slices in a pizza, think about the whole pizza as the TCPA, right? And you've got, 8 slices or something, depending upon the size of pizza. But our pizza slices are the various pieces of TCPA. So you've got, for example, and Scott talked about a lot of these, you've got the do not call list. That's a component of the TCPA that you can violate. You've got faxing. Then you've also got pre-recorded voice calls and texts. And then you've got artificial voice calls. And then you've got calls placed by an automatic telephone dialing system, an ADTS. So if each one of those components, and there's more, this is not an exhaustive list, right? There's a few more components to this pizza pie, but those are the most relevant and the largest slices, I think, for the purposes of this call. If we think about other slices of the pie, the pizza pie, we're really focusing on one. We're focusing on that ATDS component, that automatic telephone dialing system slice of the pie. The rest of the pizza pie has not been affected at all by the decision in Duguid. Okay, so let's think about that way. So obviously, TCPA, we still have to worry about it because we're thinking about all the rest of the slices. But for our purposes, what did it do with that one slice of the pie, the pizza that we're pulling out? What did it do? What is the practical implication of Duguid? So let's take a step back first. Now, as a reminder, if you're using an automatic telephone dialing system, you have to obtain consent from the party to be called before you can place calls, including text messages, to that individual. Okay, obtaining consent is a pain, right? I mean, you have to go back to your old customers, you got to get new customers' consent, and the levels of consent vary dependent upon the type of call that you're making, which we'll do a refresher on momentarily. So you have to obtain consent. The reality is, we know you all don't want to obtain consent, right? You want to take yourself out of TCPA. How do you do that? Well, one of the ways that you can do that is you don't place calls using an automatic telephone dialing system, right? So if you're not placing calls or texts using an ATDS, then you don't have to obtain consent, right? So you don't want to use an ATDS. I can't say it, so I'm just going to say automatic telephone dialing system. But so what does it do for you? Can you now make the argument that, hey, I'm not using an automatic telephone dialing system, so I don't have to obtain consent? Well, as Scott has said, the Duguid decision really gives you one argument that, and a really good one, or it vitiates an existing argument that the plaintiff's bar has that you have an automatic telephone dialing system. However, there are more arguments that you are using an automatic telephone dialing system, right? So we're talking about the capacity issue, for example. So really, when we're thinking about this one slice of the pizza pie, we're really thinking, okay, well, now we've eaten into that slice, right? We've taken away some of the arguments that the plaintiff's bar has to say you're not using, or you are using an ATDS. Unfortunately, there's still some of that pizza left that they have to eat into. So, we really can't tell you, yeah, we know you're not using an ATDS. So really what the plaintiff's bar is going to do is they're just going to shift the argument that you are using an automatic telephone dialing system, for example, capacity. And as Scott really indicated, you don't want to be the test case for these. It's a lot of litigation costs. Technology experts are expensive. Scott can tell you more about the level of expense. We're talking hundreds of thousands of dollars for these technology experts. I said we went into the wrong field. But nonetheless, they still have these arguments out there. So, that's where we are with that slice of the pie. Now, just to kind of go back to if you're placing calls, again, thinking about a few of those other slices of the pie, Scott alluded to do not call and faxing. And just a reminder, on all those component pieces, Duguid has not affected those other slices of the pie. So if you're currently or considering placing calls using artificial or pre-recorded voice, for example, Duguid really did nothing here. All right. So again, kind of just centering us on, I think really probably those of us that are on this call are in one of two camps, right? You're already placing calls or texts for, most likely, telemarketing purposes. And then the other camp of you're considering, either going on a telemarketing campaign or you're considering initiating calls and texts for telemarketing or advertising purposes. So what does Duguid do? Again, if you're in that first camp of you're already doing it, you're already, obtaining consent from the parties to be called. You're presumably already complying with TCPA. Does this change anything for you? The answer is no, really, at this point in time. I mean, maybe, as we said, Duguid really takes away, kind of eats in to that one slice of pizza. So maybe there will be more after the capacity arguments kind of make their way through the courts, and it's conclusively determined. Yeah.
Lauren, sorry to interrupt you, but we have a couple of questions, and one of them is very timely, pursuant to what you were just saying. And this question asks, would you recommend a company to obtain an external review of its telephone system to determine that it's not an ATDS? And if so, would this provide adequate support to stop obtaining TCPA consent to contact consumers for marketing purpose? And I'll let Lauren weigh in on that, but I guess my initial reaction would be, an external review is great, but it depends who's conducting the external review. And also when it turns out that just because someone external said it's not an ATDS or, what have you, a plaintiff says otherwise, are you going to have indemnification rights against the person who told you it wasn't an ATDS? So I think, Lauren, you were getting into this sort of don't throw out your TCPA compliance handbook, keep getting consent.
Yeah, Scott, I think, I would have probably turned it over to you to think about it from a litigation standpoint. And so I think that's exactly right. It's great, but are you willing to rely on it? That's a risk that you need to consider, right? I mean, I think it would be a good step, but you just need to be aware of the risk that you're taking on. And those are significant monetary risks. I mean, if these were small penalties, we would probably consider the risk to be modest. But given that these cases cost hundreds of millions of dollars, again, depending on the number and level of calls you're making, it might just be too much risk. So, and we'll get into a little bit more of the risk later in a few slides, but I think really
hey, Lauren,
the input.
Sorry,
yeah.
Just one more. This is right on your wheels, but we just got another question that says basically, what if we're just, what if we're doing only servicing informational calls, still advising no change? This sounds like extreme advice. And maybe, Lauren, you can talk about sort of, as you were saying, the capacity issue and not wanting to be the first person to have to deal with it. And also, of course, the classic dual purpose call. When is something informational? When is it servicing? When is it marketing?
Yeah. So I'm actually going to get into that on the next slide. So we will address that momentarily. So sit tight. Promise we'll get there. But kind of, I think we've pretty much gone over this slide, but I think our advice right now, while you could take steps to, bring in an expert to review your system and confirm that it's not an automatic telephone dialing system. And then based on that, if they could say that it's not, decide not to then obtain consent. That is one avenue that you could take. But, we're not sure that that's really going to protect you entirely, given the arguments that we think the plaintiff's bar still has. Like, does that system have the, future capacity? Presumably everything has the future capacity, right? With the right tinkering. So again, those arguments still will be made. Do you want to be the test case? So that's what we would just say for that. The more conservative approach is to not make any changes, right? To stay the course, make no changes to your consent practices, and not change your policies and procedures. That's the most conservative course of action, right? Now, our advice may change as we move along and see that the courts are really, not having the capacity argument. I think we can have further discussions at that point, until there's some sort of conclusive determination that this is just not a solid argument. So that's what I would say about the practical implications. And then also, if you're considering going on, placing calls or texts for telemarketing advertising practices, again, we think the more conservative course of action is really to do what you had planned to do, still obtain consent. Now you can everything's a business decision, right? So you can always consider the risks involved in that. So I promised that we would get to a refresher on, servicing calls versus telemarketing calls. So again, really a refresher. There's two types of calls that are relevant here as it relates to if you're using an ATDS. And different levels of consent are requisite for each of those types of calls. If you're just doing servicing related calls, so for example, you're a financial institution and you have a customer or a member who has an account with you. If you're just servicing their account, you don't need any sort of written consent. Really, all you need is what's called prior express consent, which has been interpreted to mean if that individual provided you with their cell phone number, that is enough. So, if you're obtaining just a telephone number, you've got the requisite consent. So I think, again, for servicing related calls, this is, it's almost, Duguid is kind of a non-starter for it. As long as you've got it's really easy, right, to obtain a telephone number. It's on every application. It's, you're obtaining it as part of your business. So if you got it, you've got the consent, and you can place servicing related calls using an automatic telephone dialing system to them. Where it gets more sticky is when we're talking about telemarketing or advertising calls, because you need to obtain prior express written consent. And that requires specific disclosures and specific consent being provided by the party to be called, which, as a refresher, we'll do on the next slide. And so that's where things get a little bit more complex, and why a business might, want to really try to get out of that TCPA governance and bring in those experts to say, I'm not using an automatic telephone dialing system, to avoid having to get that level of consent, because it's really a pain. Where we want to really highlight being careful here is when a servicing related call transitions into a marketing call, which we refer to as dual purpose calls. So it's really easy to think about, say you're sending a text message that says, we've detected fraud on your account. That is very clearly a servicing related call. If your next sentence then says, we would love to talk more about our new fraud protection service that we offer, you've now migrated into a telemarketing call. So you've now moved from all you needed was their phone number to, oh, wow, did you have prior express written consent, full of these disclosures before you sent that text messages, sent that text. So really important to note there. So,
and just Lauren, just on that one, just to clarify, because we got a question about this as well, is, generally speaking, a text, a standard, what I think of as a classic text is not a call made using an artificial pre-recorded voice, so it would be considered a call and using an ATDS if you have an ATDS. But if you have a talking text message, then maybe it's a different story. So I just wanted to plug that in there because you were talking about text.
Yeah, and that's a good question. Is that a different story? We might have to save that one for another time. But yeah, a good question. So just again, kind of a refresher on what's required for that prior express written consent. So when we're talking about telemarketing and advertising calls and texts, what do you need from the party to be called before you would place a call to them? You need consent from them to be in writing. You need their signature. You need to specifically have it authorize your ability to place advertising and telemarketing calls using an automatic telephone dialing system, or if you're using pre-recorded voice or artificial voice, that as well. And then there's a disclosure required. So basically that by executing this agreement, you're providing that authorization, and that the individual is not required to sign the agreement as a condition of purchasing property, goods, or services. And what that means is that you really can't embed this TCPA consent in an agreement that has one signature. So you're signing for a loan and you're signing for TCPA consent, for example. You can't do that, because then that would be a condition of obtaining the goods and services. You either have to have a separate section, or you've got to have a separate document altogether. And this certainly presents some problems. And just, I know we're out of time, but this is really, I think, the last slide, to hit on some of the outstanding risks and why it's important to maybe consider a more conservative approach here in the wake of Duguid, is that the penalties are so steep. $500 per negligent violation, which is per call, or $1,500 per willful violation, again, per call. So these penalties creep up very quickly. And as a result, also litigation costs can creep up very quickly too. There's no fee shifting in the TCPA. So businesses are really taking on the costs here to litigate. And there's obviously a lot of litigation on this front. And as it relates to this capacity issue, bringing in technology experts is going to cost a lot. I think, not to steal Scott's thunder, but I think he had mentioned that one technology expert was in the hundreds of thousands of dollars, multiple hundreds of thousands of dollars. So it can be very expensive. And then also to think about, too, just a couple other laws and regs that could impact your TCPA. So UDAP, if you're calling someone 600 times, I know the people on this call probably aren't doing that, but some outrageous number of calls, you could get slapped with UDAP, right? Regulators are not going to look favorably on that. And furthermore, just a reminder that there are a couple handfuls of states out there with what we call mini TCPAs. So some laws on the books that do require either certain level of consent or do restrict your ability to place calls for telemarketing or advertising purposes or servicing related calls. You just need to be aware of those. Some do have private causes of action. Some do have steep penalties. So just a reminder on that front. And obviously, you're all businesses and take great pride in your customer relations and reputational risk. And obviously always something to consider when you're thinking about which way to go. So again, just to conclude, Duguid did move the needle and reduces some risk for some businesses. But like the title of our presentation, I think ultimately we think these TCPA battles will persist. So with that, I know we're out of time, but and I don't know if Marcy's closing us out, but from me at least, we really appreciate you attending today. Marcy, you want to take us home?
Yes, thanks so much to think about and talk about. Thanks, Lauren and Scott, for a great presentation. And to all of you out there in our audience, thanks so much for attending today. We really hope the information was helpful to you and your business. If you sent us a question that we didn't get to, we'll take a look at it and we'll be in touch. As a reminder, this program is approved for continuing legal education hours. To report your hours, click on the CEU icon at the bottom of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Please be sure to complete our short survey. Again, that will help us plan future programs for you all. And this concludes our webinar. Thanks so much. Have a great day.